What does it mean? The chapter 13 has to be all the way 3 to 5 years to complete. What
okay, chapter 13 is, like we mentioned, is minimum of 36 months, minimum of 3 years, maximum of 5 years. So when someone qualifies for chapter 13, number 1, and number 2, they qualify to strip the junior mortgage. In other words, the property is worth less than what they owe on their senior mortgage. They can strip the second mortgage, this junior mortgage, in chapter 13 bankruptcy, right? But in the order the judge will sign granting that relief, it specifies they have to complete their chapter 13. So they have to finish the chapter 13, whether it's 3, 4, or 5 years, whatever the term of their chapter 13 is. Until the end, it doesn't come off the title until they complete the chapter 13.
What do you mean, like a finish? Like a
You make, okay, in chapter 13, a person makes their monthly plan payments that the trustee administers, right? So it's, again, minimum of 3 years, maximum of 5 years as far as how long it takes.
Okay. Yeah.
So until they get through it all the way, that lien is still on the property itself. If the case gets dismissed, let's say, because they can't keep making their plan payments, or if they decide they want to convert their case from chapter 13 to chapter 7, or if they want to voluntarily dismiss their chapter 13 case, sometimes these things happen, right? Then that second mortgage doesn't come off the property itself.
Okay, thank you.
Sure.
Hello, thank you. Appreciate you guys today.
Thank you.
Quick question. I had a client call in yesterday. They lost the house, I think it was on the 9th, they told me. They wanted to know if they could still file a BK after they have already lost the house, because they had nowhere to go. And I didn't know what answer to give them, to be honest with you. They want to know if they could file a BK and still stay in the house. If that was the case, if they filed a BK, would they be able to stay in the house?
Well, no. I mean, if they file bankruptcy after the foreclosure sale, that will not stop the foreclosure sale that's already happened.
Yeah, no, the foreclosure already happened.
The only thing that can change the circumstance for them is to negotiate an agreement with the bank to do like a temporary, arrangement to stay while they're looking for another place. Sometimes the banks will do that for a certain amount of time, maybe 30 to 60 days.
So BK after
But
the
bankruptcy,
fact.
no. I mean, if they have credit card debt or other problems that they want to use bankruptcy to help them remove those issues, they can do that. But it's not going to get the property back for them.
Yeah, no, they didn't want the property.
Or to stay in their house after the foreclosure.
The realtor told him that if they file a BK, that they would be able to stay in it. And I told him, well, I don't think that's true.
No, that's not true.
Yeah.
The bankruptcy has to be filed before the foreclosure sale.
Yeah, before the foreclosure.
Not after.
Yeah, okay, want to make sure, thanks.
Sure.
What to keep in mind, if the person owns the property, then bankruptcy can do a lot for that person. But if the person already lost the property, doesn't have the ownership, just like the landlord, tenant doesn't have the ownership, doesn't have that many rights through bankruptcy.
Yeah, they lost it on the 9th. She said if she were to file bankruptcy, would she be able to stay in there for 6 months? Because that's what the realtor told her. I was like,
It's a new part of bankruptcy law. Never heard of it.
so I just want to make sure that's not the case, right?
Yeah. Sorry to say that.
Hi, I'm Catherine Torres.
Hello.
I want to ask you, we hear a lot about, or I read about, if you have a second, you can get rid of it with your bankruptcy. What about people that have one loan, but they're upside down? Could they get a balance reduction? Because you hear about that once, once.
The question is, can a person get a balance, like a cram down on the principal, residence or on a mortgage? They cannot do it on the first mortgage unless it's like an investment property, like we discussed, right? If it's a principal residence, you cannot force the senior lender to reduce what's owed to them, even though the property is less than what they owe on that first mortgage, right? If it's an investment property, you can do that, but you have to repay what it's worth now when you file the bankruptcy as of today's date over 3 to 5 years. So it makes sense, like if you're in, yeah, right, it's a lot of money for some people, but if you have a property in, North Las Vegas or something that's worth $20,000, maybe it makes sense, maybe not, I don't know, but that's an option. But for your principal residence on your senior mortgage, you cannot force them to reduce their principal balance.
So it's really more an advantage for somebody who took a second or a credit line.
Yeah, the advantage is to allow a person to strip that totally undersecured junior mortgage or equity line. There's not $1 equity in which that junior mortgage can attach to the property, then they can strip that in Chapter 13 bankruptcy, but not as the senior mortgage for their principal residence.
So, in other words, the first, if it's all one mortgage and there's only one that person probably is more of a candidate for a short sale, because I mean,
yeah,
the others might have a chance, but
right.
the other.
Well, a lot of times also there is the balance on the first is a lot higher than the value of the house. And then there is a second. This person might still be better off for the short sale because they still have a huge balance on the first, even though they could still get rid of the second through Chapter 13. But it still might be better to do the short sale because that's the only way you can reduce the principal balance on the first.
Right, okay, thank you.
Good morning, I have 2 questions. I just opened escrow on a short sale, but this case, Chapter 7 already discharged.
Okay.
So if I complete the short sale, what happens to the negative amount? The loss that bank takes? Will they?
They don't have the right to go after the person.
Okay.
I mean, that's why they're doing the short sale.
Okay, 2, I have a client that's married, he wants to file bankruptcy. He's separated, they're not legally separated, but they're separated. The wife has a house under her name, but she's just on title. The son is carrying the loan. I guess the son bought the property, title got transferred to her name, there's about $200,000 in equity. His question is, can he file bankruptcy and not affect the wife's equity?
Okay, so let me make sure I understand the situation. There is a couple who lives in the house.
The wife. They're separated. They're legally married, but they're separated. And he wants to file bankruptcy.
Well, can he get back together? Because the law is kind of like in between on that one, because we need to know what is his principal residence. There are a lot of limitations on
He
that.
owns his own house.
Separately.
Separate. And again,
Yeah. See, if the couple lives together, it doesn't matter who holds title. If one person holds title, another spouse can still file and get rid of this, whatever they have to do about the second mortgage or whatever. But if they're separated and he has another homestead, he cannot claim homestead in this house, you see? Because there's a lot of equity. He doesn't live there.
yeah, but she's stopping him from filing bankruptcy because she's afraid that they're going to come after her equity.
The
Do you understand?
investment property, the son is paying for.
He had 2 properties, he
Title for it.
foreclosed one, so I guess there's a second lien on that property that he foreclosed that it's collecting from him, and he has other debt, so he wants to file bankruptcy to get rid of that debt and second lien that it's collecting.
I understand. First of all, this is the type of situation that we really need to sit down with the client and get a lot more information. Because possibly if some of her, if it is treated as a community equity, sometimes they're better off filing for divorce and have the family judge state that this equity is her in lieu of child support or alimony. If there is a final judgment from the divorce court, then there is no danger to her equity. Then he can do whatever he wants to do, because bankruptcy court will recognize the divorce court, family law
But
judgment.
this will be a special case if
Uh-huh.
they don't get divorced, correct? A special case for you guys to handle.
No, not especially. We would need to analyze it more carefully.
Okay.
But if they do get a divorce, it will be easier for them.
Okay, I see. Thank you.
Thank you.
I have a question on,
First, I want them to get.
actually it's on a brochure about Chapter 13 bankruptcy.
Yeah.
You mentioned that a person can have their second and third mortgages eliminated while keeping their home. 2 questions. One is, are they required to pay back the balances of the second and third mortgages over the 36 to 60-month period? No, it's totally wiped out?
The answer to that is no. The second and third mortgages, if they're qualified to do the lien strip in Chapter 13, they're treated just like their other unsecured debt, like their credit card debt.
Even though they were secured?
They were secured at the time, but by operation of law through Chapter 13, if they qualify, they become treated like unsecured debt.
Okay.
And then if it completes 3 to 5 years for it to come off the actual title.
Okay, so the second and third mortgages are wiped out totally. What about the first mortgage? Is the balance on the first mortgage reduced to the value of the fair market value of the house?
No.
No?
No, not if it's your primary residence. If it's an investment property and you have 3 mortgages, you can get an appraisal report from an appraiser saying it's only worth this much, and you can pay only this much what it's worth today over 3 to 5 years, and that's it. The rest of it gets wiped out. But if it's your primary residence, no, you have to pay what you owe on it. If you fell behind before the bankruptcy, you pay that amount over 3 to 5 years, among other things sometimes. but you cannot reduce the principal balance.